the money you have coming in under Nevada law is enough to pay your child support. State ready to proceed?
We are.
All right, case number R. I have present along with the district attorney's office. We don't have Mr. President. Oh, this is here. Just in time, sir. Sir, just to get you caught up, I just called the case and I checked to make sure that Ms. appearing by video was able to hear me. She was able to hear me, so now you're here. We're going to get both of you sworn in so you can give testimony today. Can I have you raise your right hand, please?
You need to do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ma'am, do you also swear to tell the truth?
I do. My legal name is currently.
So sorry, and I probably have very old information. Can you
Would you
spell
like me
that
to
for
spell it? Yes.
Yes, please. And did the clerk get that?
Yes.
Excellent. All right. So, all right. So go ahead and have a seat. Make yourself comfortable. So this is the state's motion to hold you in contempt for not paying child support. So Judge Gordon issued an order to show cause in this case, compelling you to come to court today and explain why you haven't been following the child support order. The motion that was filed with Judge Gordon indicated that you hadn't made a child support payment since September 11th of last year. Now, the motion was filed a couple of months ago. Before we go too much further, I'm going to ask the state to update me on anything that may have happened in terms of payments in the couple of months since the motion was filed.
Thank you, Honor. So from May 1st, 2024 to July 31st, 2024, an additional $2,106 came due. Respondent paid $1,100 during that time period. There were many months without payments from October 2023 to May of 2024. And then he paid $100 in June 2024, and then he paid $1,000 in July 2024.
Okay. So normally in advance of these hearings, we would have you fill out a financial disclosure form. But you got here a little late, so you didn't have a chance to fill one out. I am still going to ask you to fill one out before you leave. We'll give you a form and a clipboard and have you sit down and take care of that. But because I don't have a financial disclosure form, we're going to have to ask a bunch of questions today about what's going on in your life financially to try to determine whether or not your failure to pay was willful. So the way that contempt works is that if you could pay your child support and you didn't do so, then you can be held in contempt for not paying. If you truly couldn't pay your child support for medical reasons or other things going on in your life that would cause it to be impossible, then perhaps you're not in contempt. But that's what the purpose of today is, to find out. So at this point, rather than me ask you a bunch of questions, I'm going to turn you over to the DA, and he's going to ask you questions about your financial situation, and then we'll give you a chance to respond at any point once he's done.
So, sir, can you explain the lack of payments this year, just starting from, say, January to May?
I was told not to pay during those times because I had to get a paper signed by my doctor. But my doctor was she's still out of country right now from the VA. And then they gave me a time limit, and then the time limit expired like 2 months ago. And then that's when I started paying again.
So are you saying there's a medical reason that might prevent you from working?
Yes.
And what is that?
I'm 100% disabled.
Okay. Can you explain the nature of the injury to the court?
I had a bomb fall on me.
And what specifically prevents you from working today?
All my joints and bones.
So have you completed a medical assessment form? Have you had your doctor complete the information they needed to?
She's still out of the country right now, so she can't do the paper until she gets back.
Okay. How are you currently supporting yourself?
Just through the VA disability.
And how much do you receive per month?
Like $3,200.
Okay. And how long have you received the VA disability?
Like 6-7 years.
Okay. So then you had income those months that you weren't paying child support, correct?
Yeah, the same amount.
Okay.
The house got refinanced though, and the bill went up triple what I was paying.
Your Honor, I will provide him with a medical assessment form today. And so, sir, if you're going to see your doctor, you can have your doctor complete this.
I think she'll be back in 6 months or so.
Are you seeing another doctor? Is there only one?
There's only one, and it takes 2 years to do another one, so.
Okay. Well, even with the VA disability income, it appears there's a source of income that can be utilized to make child support payments, and for many months there was no payments.
That's because I was trying to get my doctor to sign a paper and I found out that she was out of the country, then I started paying again once the timeline was up.
Did you bring a payment with you today, sir?
A payment?
Yes, sir.
I brought my checkbook.
And how much could you pay today?
I took out a loan, so it depends how much do I have to pay?
So we do have an audit. It's only through February 29th, 2024, but at that time the arrears were $13,683.73. Do you have the ability to pay off your arrears today?
Not the whole thing, no.
It's unusual that someone would, but do you have an amount you could pay towards those arrears today?
Probably like $2,000-ish.
Okay. Ma'am, is there anything you'd like the court to know?
Hi, yes, absolutely. So he has been on the VA disability since 2000, about 9, 10 or so. And we had lived off of his disability throughout our entire marriage. He was only getting $2,200 a month at that point, and that was enough to support me, my 3 children, and himself, and the house, and all of the bills. And while the house price for him did go up because he refinanced, he was court ordered to sell the house and split the assets, which he was in contempt of court and did not do for a year and a half through the divorce case. And he finally decided that instead of selling the house and getting that money, that he wanted to refinance and keep the house, and he chose to have a astronomical bill to pay every month.
So I do want to point out that 26% of your VA income is actually a little more than what your current child support obligation is. Meaning even without the ability to work, even 100% disabled, the money you have coming in under Nevada law is enough to pay your child support, or presumptively enough to pay your child support. So for instance, if you were to apply for modification, your child support would not go down, it would likely go up. So the fact that you have taken on other bills is not an excuse for not paying the child support obligation. It looks like you want to tell me something, sir. Go ahead.
I'm in the process of selling the house right now.
So I want to make sure that you both understand that your divorce case, that's where this child support order came out of, that is your primary case. This is a case to simply enforce child support. This is a court of limited jurisdiction. We have very limited ability to do things in your case. A lot of what you guys are discussing, or what you were discussing, would be in front of Judge Gordon at this point, wouldn't be in front of me. I'm just here to decide whether or not your failure to pay the child support order was contemptuous or not. So at this point, it looks like each and every month you had enough money coming in to be able to afford to pay the child support as ordered. I know you have other bills, but 26% of $3,200 is $832. So this is actually less than the guidelines contemplate child support is supposed to be for your income. So it won't matter whether you document your inability to work or not, you still have enough income coming in to pay child support, at least presumptively under our guidelines. You're looking at me quizzically. Is there another question?
So the bills aren't taken into effect?
They're not.
Okay.
So just so you folks both know, every state has an option of determining how much their child support statute, or how their child support statute is going to work. So California, for instance, has one of the most complicated statutes in the entire country. They take into consideration both of your incomes, they take into consideration both of your bills, they take into consideration timeshare. It's very, very complex. In fact, it's so complex that you can't just sit and do it in court. You have to use a piece of software to get it done. But it does take into consideration each and everything going on in your lives. Now, that being said, it starts at a much higher rate and then works its way down. And in the end, child support orders in California are typically the same as Nevada. Nevada has the simplest child support statute in the entire country. It used to be a little more complex, but in the 2019 legislative session, the legislature decided to simplify it even further by removing a number of the adjustment factors, but reducing the percentage in each instance. So child support for one child used to be 18%, for instance, now it's 16%. But many of the adjustment factors went away. Child support is mostly just me and my calculator figuring out what the percentage of gross monthly income is. So I get that you have additional bills and other responsibilities. Pretty much everybody does. But as I'm sure you're aware, it now costs a lot more money to raise kids. The cost of everything has gone up. I'm hoping that your VA income has some sort of COLA adjustment. But ultimately, again, what I'm doing today is pretty simple and pretty straightforward. So I think with the district attorney's office, they may not request contempt if you're able to come up with a certain amount of money today. But I don't know what that dollar amount will be. What amount would the state be comfortable accepting in order to have him not found in contempt today?
Your Honor, we'd be seeking that he pay off all of his arrears that have accrued for those months of missed payments. So from October 2023 to present, I don't think he's indicated he has the ability to do so today. He did bring the $2,000. We do appreciate the good faith payment. However, I would request the court find him in contempt and sentence him to 10 days in jail, but stay that time based on his good faith payment that he made. And I would request a return hearing in 60 to 90 days for the court to monitor his payments between now and then.
Do you want to weigh in on any of this?
That sounds good to me.
Okay. Do you want to respond to anything that's been said?
I was gonna ask him a question. If I get this paper signed, they told me that all the child support payments go away.
So no, sir, that's a medical assessment form. What that does is it informs the court of your ability to pay child support, but at the current time and for years, you've had VA disability income. So based upon that, it appears you would have an ability to pay child support.
They said that if I'm not able to work and that if I'm 100% disabled for medical reasons, then they would, in lieu, get rid of all the child support payments.
So that could be possible in certain circumstances, but where you have an income, it doesn't matter that you're disabled, you have an income that could be used to satisfy the child support obligation. And because of that, then we can continue to garnish that or have that paid towards the child support obligation in your case.
You guys' website was down too for a couple months. It changed or something. I couldn't make payments on it.
I'm not aware of that. I know we switched payment providers, and so perhaps you were accessing the old one, but we can get you the new information today.
Okay, yeah, I took screenshots of it. It said I had no balance in anything.
Okay. Yeah, and our office is always open that you can make a payment here.
Okay.
You can make a payment over the phone.
You guys got rid of the kiosks though, right?
Yeah, we do have a state collection and disbursement unit in the building, and they may be able to help you process your payment today.
Okay.
Otherwise, you can always pay by phone. MoneyGram, I think at Walmart's, at Walgreens.
So to make it a little easier on you, you see there's 3 pieces of paper in front of you. The middle sheet of paper gives you instructions on how to use the app to make your child support payment. The skinny one that's all the way to your left, see how it has a QR code in the center of it? You might as well grab copies of those. The one all the way to your right is in Spanish. It's just the same. That's the Spanish one.
Okay.
You can have it, but
I don't have a QR code capability.
okay. So the only thing, take it anyways. The QR code is just to give you the latest, greatest information. So the sheet doesn't get updated every day, but that QR code will take you to the latest information. For instance, the state is in the process of accepting Apple Pay and Google Pay. That's the kind of information you would get from the QR code. But otherwise, as the DA points out, you can make a payment at any Walmart in America. You can make a payment at a significant number of Walgreens, CVS's. There are dozens of mom and pop grocery stores all over the city that accept child support payments.
How do I do that?
So any grocery store or CVS, you're getting information on it right now. So the provider that the state uses for those small places is a provider. It's called MoneyGram. So if you walk into a 7-Eleven and you see the MoneyGram logo on the window, you'll know that you can make a child support payment there. MoneyGram charges a $4 fee, and Walmart also charges a $4 fee.
Including the $8 fee from...
No,
Oh, okay.
there's no $8 fee. It's cheaper to pay at Walmart.
Okay.
The $8 fee is a different vendor that you're using through the phone system.
Understood.
Okay, so, sir, you missed a bunch of child support payments. in months in which income was coming in and you had the ability to make your child support payments. So for that reason, the court's going to hold you in contempt today.
Okay.
The state is not asking that I put you in jail today, and I will not be putting you in jail today, but I am going to sentence you to 10 days in jail. That jail sentence is going to be stayed, and it is not to punish you. This is civil contempt, not criminal contempt. The goal is to get you to pay your child support. The purpose of the jail sentence is to incentivize you to pay the child support. There always has to be the ability to purge civil contempt. In this case, you can purge civil contempt by making your child support payment each and every month for the next 6 consecutive months. That would be September, October, November, December, January, and February next year. If you make those child support payments every month like you were ordered to do, then the contempt from today's hearing is going to be purged from your record. It will go away and can never be imposed.
How much is it?
It's $702 a month.
So, 2 months for.
Remember, we do
There's
have
a-
arrears. I would
so,
request an arrears payment.
Under Nevada law, when you owe back child support, you're required to pay that at 10% of your current child support. They've already administratively been assessing it, but now I'm going to go ahead and find that you also need to make a $70 a month back child support payment.
772.
So it's $772. That's the total amount due. You pay that every single month like you're supposed to, and today's contempt goes away. Now we're going to come back to court in probably about 3 months. I'm going to see when the clerk has a date available for you. If it won't be enough time to get today's contempt purged, but it will be a good opportunity for us to see what you're doing and see how things are going and make sure that you're paying like you're supposed to.
So if
Yes, sir.
if I sell the house and pay off the whole arrears, then
You still it would go back to $702 a month. So if
Okay.
you paid all the back child support, you'd still have an ongoing obligation to support the kids.
that's okay. Got it.
Okay? Does all of that make sense?
Yes, sir.
Do you understand what the court expects of you between now and the next hearing?
Yeah. So I still get the paper signed though, since.
So you can do that, but here's the thing. Under certain circumstances, if you can't work and you aren't earning any income, that would qualify you to have your child support reduced, perhaps even eliminated depending on the circumstances. But you have an income coming in, and even if you can't work, your child support is still going to be based on that income. And as we talked about earlier, that's income consistent with what you're paying now. So really, not a whole lot is going to change.
That's what the caseworker told me, that I wouldn't have to pay.
The caseworkers don't work for the court. I don't even know who your caseworker is, and I apologize if they gave you incorrect information.
Understood.
So, Ms. do you have questions for me today?
Yes. Once he gets the financial disclosure form updated, will it be through this court or through the family court?
That's a great question. It will be through this court. So he's going to bring it back in a few minutes. He's going to give it to the marshal. The marshal's going to give it to the clerk who will file it. It's not the same financial disclosure form that you're used to using in a divorce case. And this is a short form. It's one that's been used in child support court for about 20 years. Did you have other questions for me, ma'am?
I guess just, will that be like back paid? From the amount of time that his, monthly income went up from $2,200 a month to $3,200 a month?
So here's the thing.
Since he did not report that?
Child support doesn't float. If either of you, this is the order. It comes out of an April 28, 2011 order it was actually what you guys agreed to. So the specific numbers as how we got to this point weren't actually disclosed in that agreement, just that was your agreement. It has been more than 3 years since child support has been looked at by any court, at least as far as I can tell, which means either of you have the right to have child support looked at again. You would do that by filing a motion and putting it in front of this court or putting it in front of Judge Gordon. You have an option of doing either. But either of you can ask for me to look at child support again, but it doesn't automatically change. It requires a motion and it requires a new order. Ma'am, do you need information on how to use the self-help center? Sir, do you need information on how to use the self-help center?
Not right now, thank you though.
No. Ma'am, do you need information on how to use the self-help center?
I believe so. Is it possible for the DA to reach out to me? They have my contact information.
So the district attorney's office can and often does file motions for people. So if you'd like to request that either of you would like to request that the district attorney's office file a motion, you communicate that to your caseworker. They'd have you fill out some paperwork, and then they determine whether or not it's appropriate to file a motion for you.
Do you have a number for my?
All right, thank you very much.
All right. Okay, so our next court date will be,
November 6th, 2024, 10 a.m.
did we go over the back child support?
I thought you wanted.
We did, Your Honor, but we did not get a judgment on it yet.
Okay, so you guys both got copies of the audit, correct?
In the car, yes, sir.
Yeah. And ma'am, you got a copy of the audit, right?
Yeah.
All right,
Yes,
so
I
the
did.
audit says that through February 29th, and of course, that's not going to include the recent payments, nor is it going to include today's payment, but the back child support was $13,683.73. That will become the new judgment that will supersede the November 30th, 2019 judgment. Did either of you have questions about that audit?
I saw like 20,000 on
No,
there
Your
or
Honor.
something. I was wondering what that.
So the audit that was filed with the court was that $13,683.73 figure. So I don't know if you saw something else. It wasn't something that was filed with the court.
On the right hand side, it has like a $20,000 number. I was wondering what that was.
Well, again, that's not what the district attorney's office is asking the
Okay.
court today to adjudicate. So that's got to be good, right?
Right.
All right. So I'm going to prepare an order for today's hearing. That order is going to be mailed out to both of you tomorrow morning by the district attorney's office. Ma'am, because you're not here, you're just going to have to get it in the mail, unfortunately. I think do you live in another state?
I do, Your Honor.
Okay. I do want to let you know for the next hearing, the Zoom information that you have, it will be the same Zoom information next time. So hang on to the ID and password information. And sir, you had a question.
If I sell my house and I'm moving to the East Coast, like Connecticut or something,
So-
how do
So there are circumstances in which the case would move with you,
okay.
but if you move to another state, that state will only accept the case for enforcement purposes if they can verify that you live in the state.
Okay.
So if you move to another state, you need to contact your caseworker here, give them your address, and give them that information. They'll contact the state you've moved to, and if that state verifies that you're there, then the case will move to that state for enforcement.
Okay. Got it.
All right. Okay, sir, you're here, so I'm going to if you can wait just a few minutes, I'm going to finish typing your order out, and then we'll get you a copy.
The financial disclosure?
Yeah. Oh, yeah, you have to stay anyways because you're doing your financial. So while you're working on that, I'll work on preparing your order, and then we'll put a copy in your hands before you leave. You'll also get one in the mail next time.
All right.
All right.